Right. Minutes.
Good morning. The 36th District Court in the state of Michigan is now in session with the Honorable Judge Donald Coleman presiding. Our court is in session. There will be no eating, sleeping, talking, or gum chewing.
Thank you. Mr. Fortner, do I have Attorney Fortner? If you're there, say something at this time, please.
Judge Coleman, I'm getting him on right now. I know he's got money matters in front of you. I'm letting him know you've taken the bench.
All right, thank you. This is case number 24-160617. This GFL Environmental USA versus M&M Petromark LLC. The matters before the petition to show cause. Your appearance for a GFL, please.
Christopher Lavasser for GFL, P35981.
Thank you, Mr. Lavasser. Good morning to you. I'm looking for counsel for M&H Petromark. If you're on the Zoom, say something.
No, counsel, Your Honor.
Who do I have on Petromark?
Mohammed Hamdan?
All right. Did you say the last name again?
Hamdan?
Thank you, Mr. Hamden. Good morning. Good morning to you, sir. All right, counsel, tell me what's going on here. Obviously, there's an LLC, and I don't know if the defendant can be represented, can be unrepresented. But go ahead, sir. Let me talk to you.
Yeah, that is correct. At one point, they indicated in my office that they had an attorney, but apparently not. And they are appearing today without an attorney, or he is appearing today without an attorney for this show cause hearing. I am willing to conduct the creditor's exam today if that's what the court would prefer to do, but also a finding of him being in contempt would also be acceptable, obviously.
I'm sure kind of not appearing with an attorney in this matter is borderline in that regard. Mr. Hamden, are you prepared to provide the information that was requested in the subpoena, sir?
Your Honor, I could translate for him. I'm his son, if that's okay.
No, it has to be are you a certified translator, sir?
No, I'm not.
Yeah, can't let you do that. All right. So the only thing that I can say in this matter is that he's going to have an attorney to appear regarding this matter. And if not, the court will in fact issue a bench warrant regarding this matter. So I'm going to adjourn it for a couple of weeks. Give them an opportunity to come in with the attorney. You have to appear with a lawyer. If you don't appear with a lawyer, then that means that you're not really prepared to go forward on this. And that would mean that the court would have no choice but to issue the bench warrant on the show cause. So I'll adjourn the show cause and set the next action date regarding this matter. That's going to be the 10th of March. March 10 at 10 o'clock a.m. I'm sorry, excuse me, April 10th. Thank you for I can't go backwards. April 10th. April 10 at 10 o'clock a.m.
Thank you, Your Honor.
All right, so parties have to be here. There has to be a lawyer representing Petro. Somebody's got to be here. Otherwise, I'll have to issue a bench warrant.
Your Honor, he's going to Saudi Arabia on the 8th of April.
No, 14.
Oh, on the 14th. When you go?
Look.
Oh, he'll be here. I'm sorry. I apologize.
Sounds good. Thank you. What's your name, sir?
I'm his son, Sam Hamdan, Saeed Hamdan.
All right. Thank you, Mr. Hampton. All right. Good day to both of you. All right. And good day to you, Mr. Lavasser. We'll see you on the 10th of April.
Thank you, Your Honor.
At 10 a.m. The court is calling case number 24-15-9615. This is Portfolio Recovery Associates versus Nicole Dooley. The matter is before the court, sent on in regard to the filing of a motion for summary disposition, your appearance for the plaintiff in this matter.
Good morning, Your Honor. Jeffrey Beers, P 41693 on behalf of Plaintiff Portfolio.
All right, thank you, Mr. Barris. Good morning to you. I'm looking for Nicole Dooley. Are you on the Zoom? Say something at this time.
Yes, I'm here. Good morning.
All right, good morning to you, Ms. Dooley. All right, I see the motion for summary disposition. I'm looking for a written response from Ms. Dooley. I don't see where you filed a written response to this motion. Is that correct, ma'am?
We have a consent, Your Honor.
That's correct.
All right, Mr. Barris is indicating that somehow something has worked out here. So let me hear from Mr. Barris. I'll come back to you, Ms. Dooley. Go ahead, sir.
Okay.
Yes, Your Honor. We had an opportunity to speak in breakout room this morning, and we agreed to a consent judgment as follows in the amount of $2,964.72 at $100 per month, starting April 25th, 2025 at 0% interest. And after the judgment is paid in full, plaintiff will agree to set aside judgment and dismiss case with prejudice, and we will submit under 7-day rule.
All right, Ms. Dooley, you've heard the terms. I've noted them at a consent judgment at $2,964.72 with a monthly installment of $100 per month commencing on April 25th, continuing until the judgment is paid without application of interest. And when the judgment is satisfied, the plaintiff agrees to set it aside and to dismiss the case with prejudice. Is this your agreement regarding this matter?
Yes, it is.
All right, I'm going to note then that the parties have resolved the matter, and that will conclude this matter. I will await the order, and that will be the end of this. I wish both sides well. Okay, too.
Yeah. Thank you. Thank you,
Your Honor.
Judge. Thank you,
Have a
Mr.
good day.
Beers. You
Thank you.
too. Thanks.
The court now calls case number 2416-4917, LBNB Funding versus Arbery, Lyons. The matter is before the court, settling for a first hearing. This is a status conference. The plaintiff in this matter is $934.70. Your appearance for the plaintiff, LBNB Funding, please.
I'm the attorney of record, my bar 5222.
Mr. Rosen, good morning to you. Your connection is horrible. I don't know if you can.
Let me sign out and try signing back in, Judge. That usually does it.
All right. I'll be here waiting so we can go forward. This is 24160107 Acupuncture Health versus City of Detroit. The matter is before the court, set on for a final pretrial conference. Your appearance in this matter for acupuncture, please.
Good morning, Your Honor. Mark Gozer for the plaintiff, P number 79070.
Thank you, Mr. Gozer. Good morning to you, sir. For City of Detroit, your appearance, counsel.
Good morning, Your Honor. Alfred Ashew, PA 2536.
Thank you. Thank you, Mr. Ashew. Good morning to you as well, sir. I did set this for the final pretrial conference. Does somebody update me? Looks like I need to set this for trial. What's going on? Mr. Gozer?
Yeah, I think a trial date would be best, Your Honor. We have had some discussions today. I think we're hopefully moving towards resolution, but I think trial date, we're ready for it.
I'd agree, Your Honor.
All right, thank you. All right, so the court will set this matter on for trial. Madam Clerk, can we do that on the 12th of May?
Yes.
All right, May 12th at 10:30. May 12th at 10:30 a.m.
That works for plan.
Good day to you, gentlemen.
Yeah, I guess that works for me. Thank you, Your Honor.
And we're back on the record regarding LBMB funding, the suffix 4917. And Mr. Rosen is present. Go ahead and enter your appearance, if you will, sir.
Thank you, Judge. I'm Attorney Richard Drusen, my bar number 35222.
All right, thank you, Mr. Rosen. That is much better. Do I have Aubrey Lyons on this Zoom? Say something if you're here, sir.
This is Aubrey Lyons.
All right, thank you, Mr. Lyons, and good morning to you, sir.
Good morning.
All right, Mr. Rosen, as an officer of the court, update me on where things are regarding this matter, sir.
Judge, I spoke to defendant while the case was in the breakout room. I have no settlement to put on the record. I told Mr. Lyons in the breakout room then I would be back on the record. I'm asking for a scheduling order, which is one of the takeaways of the status conference hearing. And Judge, asking for the scheduling order, I would also ask for 60 days discovery. With that, I rest.
All right, Mr. Lyons, the next step in this matter, where the parties have not reached a resolution, is for the court to set it up for a pretrial conference, and in the interim to sign and issue a scheduling order that will allow for the exchange of information between the parties. Whatever either party wants, all they need to do is request it in writing. If the relevant information is available, that information will be submitted. That's what will happen over the next 60 days. So I am setting it for a pretrial. A new action date regarding this matter is going to be the 29th of May. I'll come to you, 5/29/25 at 9:30 a.m. You will receive a scheduling order in the mail from me in the next few days. Mr. Lyons, you had something you wanted to tell me. Go ahead, sir.
Yes, I'm not sure why it's being extended. Based on my response, I would like it dismissed based on they violated fair debt collection practices, and my only source of income is disability, and I'm disabled for life. And
thank you. Nothing that you put in your answer provides a basis for the case to be dismissed. The fact that you're on disability income would mean that if a judgment is entered against you, it would be likely uncollectible. Certainly, your disability income would not be something that would be subject to collection to the extent that it's a federal benefit. But that's an issue that is not before the court at this time. You raised it. You still want to talk? Go ahead. Let's hear you.
oh yeah, no, I'm just whatever. If they want to extend it, I'll. I mean, do I have to do anything else, or just wait for?
It's not a matter of them extending it. This is a lawsuit that's been filed before the court. The plaintiff filed.
Right.
Are you going to listen, or are you going to tell me today? You want to tell me what to do, or you going to listen?
Oh no, I'm listening. I was just saying. No, of course I'm.
Listen, only one side talks at a time. When I'm talking, nobody talks.
Okay.
Nobody talks. Okay. So this is a lawsuit. You filed an answer. Because you filed an answer, then it is put into litigation. Because you filed an answer, your answer will be defaulted. It's litigated now. Litigation starts. Parties don't agree. If somebody says that if parties are able to come together and say, well, we've reached a resolution, then it doesn't get litigated further. If they say we disagree, we don't have a resolution, then it goes into litigation. That's what the scheduling order is about. That's what the next action date is about. You have the right to motions. The other side has the right to file motions. Anything that is filed, I will consider it and make a decision as to what the outcome will be. Otherwise, what the case does is it goes through the normal court process, and ultimately somebody will either file a motion or I will set a trial date, something along those lines will happen, and we'll get to a final resolution. Unfortunately, today is not the day to get a final resolution because the parties don't have an agreement. All right. So the next date again is going to be the 29th of May, and you will get paperwork in the mail from me in the next few days. Both sides will, with the new date and with allowing for discovery, exchange of information, et cetera. All right. I wish both sides. Good day to you.
Apologies. Apologies.
Apologies. We're just working through it, sir. I wish you all the best.
Okay.
All right. Good day to you.
Yeah.
All right. The court now calls case number 24174946. This is Credit Acceptance Corporation versus Stephen M. Smith Jr. The matter is before the court, set for a status conference. This is the first hearing regarding this matter. The claim is $14,515.18. Your appearance for credit acceptance, please.
Good morning, Your Honor. Brad Johnson, P75416, on behalf of the plaintiff.
Thank you, Mr. Johnson, and good morning to you. I'm looking now for Mr. Stephen Smith.
How you doing?
All right. Good morning to you, Mr. Smith. All right. I received the answer in this matter, and the answer seems to acknowledge responsibility for the indebtedness and as a request for a payment plan. Talk to me, Mr. Johnson, regarding any discussions that might have been had.
Your Honor, happy to report I spoke with Mr. Smith in the breakout room and we agreed to a consent judgment, and I can place the terms on the record.
All right. Go right ahead, sir. Let me hear it.
Mr. Smith agrees that a judgment in the amount of $14,820.97 shall enter. That amount is inclusive of the amount pled for, court costs, and the statutory attorney fee. Mr. Smith agrees to pay back this judgment in $200 bi-weekly installments beginning April 16th of this year, and then every 2 weeks thereafter until the judgment is paid in full. So long as Mr. Smith makes his payments as agreed, a plaintiff shall not issue a periodic garnishment or non-periodic garnishment. Plaintiff does reserve the right to issue a state tax garnishment, even if Mr. Smith is still paying on this judgment as he's agreed to. And all this has been explained to Mr. Smith in the breakout room.
Mr. Smith, you've heard the terms, and I've written them down. Is this in fact your agreement regarding this matter, sir?
Yes.
All right. I would then note for the record that the parties have in fact reached a consent regarding this matter, and I will sign the document upon its presentment to the court. So, Mr. Johnson,
Okay.
Is there a mutual agreement that you can sign off on this document for Mr. Smith?
He hasn't seen it yet. I was having issues with my email, so I couldn't get it to him. But I said I would mail it, but it does comport with what I said on the record.
Mr. Smith, if he sends, is it okay if he applies your signature to this matter by consent, given that this is on the record, and my notes say that judgment would enter for $14,820.97 with a $200 bi-weekly payment towards that amount. Payment began on 4/16/25. No garnishments are allowed, except there is a right to garnish the state income tax. That would be the only garnishment as long as the payments are timely made. But the document says that. Is it all right if the court go ahead and sign off on that, sir?
No, he told me he's going to email it to me, so I still want to see it.
All right.
I mean, he said he's going to mail it to me, not email it. He said he's going to mail it to me, so I still want to see it.
All right, yeah, and you'll get a copy of it once it's entered too. So go ahead and do it that way, sir, and then get it to me, Mr. Johnson. All right. All right. I wish both sides well. Thank you.
Okay, thank you.
Oh, Your Honor. Just some housekeeping. Mr. Smith does have a new address, so I'm sure the court would want to know that.
All right, and what he would need to do, and Mr. Smith, if you would use your device to chat that new address to me, you know how to do that, sir?
Yep, I'm about to send to you right now. It's going to be a direct message to you.
All right, so and once you put it in the chat, I'll make sure that the file is updated with your new address, okay?
Okay, thank you.
All right, thank you. All right,
yep, I just sent it to you. Have a good one.
Thank you, sir.
Thank you, Your Honor.
All right, you're chatting it to me, Mr. Smith, correct?
Yep, I'm about to send it to you right now.
Okay, real good. All right, thank you.
Mm.
All right, case number 24-152-636. This is Rotnick Chiropractic versus Essentia Insurance Company. The matters before the court regarding the various items that have been filed in this matter.
Your Honor, I apologize. This is still Mr. Fortner's assistant. He's in person in Wayne County. I've texted him a couple times that you're ready. So I'm hoping he'll be over here shortly. I apologize.
All right. All right. And I see that counsel on the other side is here as well. So we're trying to give Mr. Fortner here, counsel, if he has your matter and two other matters. So give it a few more minutes.
Okay.
I just sent it. Did you get it? This is Stephen Smith talking.
Just 1 second, Mr. Smith. No, I don't have it.
Okay, I'm about to try it again.
You chatted it to the judge, right?
Yes, Donald Coleman, right?
Yes.
Yep, I sent it there. I sent the direct message. I sent 2 messages.
I don't see anything in the chat.
All right, I'm gonna try it again. It's a direct message. It's a direct message to you.
I got it now.
Okay,
Just
thank you.
All right, we're correcting the file in that regard, so.
Okay, thank you.
All right, thank you.
Judge, is that ASHU trial gonna be on Zoom? We don't know. She didn't say.
That's, I mean, I did not specify, so it can be if they show up in person, we'll go that way. So I'm not sure.
Okay. Okay.
Thank you.
Uh-huh.
As far as I can tell. Hello, Your Honor.
Good morning, sir. We are on the record in Rodnick Chiropractic versus Essentia Insurance Company regarding 24152 your appearance for the plaintiff in this matter.
Yes, Your Honor. Attorney Michael Ford is here on behalf of plaintiff P46541.
All right, thank you, sir. Good morning to you. For Essentia, your appearance at this time, counsel.
Good morning, Your Honor. Christian Verbach on behalf of defendant Essentia, P83054.
All right, so it appears this is before the court on a motion for relief from a previous order of the court. You may proceed at this time, Mr. Ford.
Sure, Your Honor. Honestly, I forgot what the motion was. I forgot what the previous order was. Honestly, I didn't. I'm in court. I didn't bring any pleadings with me. One of counsel I go to. I think is this one counsel. I got it. I've got it. This is the one where they said the claim was capped at $500, but the motion said $900 and some dollars. Is this the one I'm thinking about?
Yeah, this is that. That's the motion that that you indicating that you're seeking relief from that order that capped the recovery at $540.74. So tell me about that, Mr. Ford, and then I'll hear from the other side on this, sir.
Well, essentially, that was essentially what the argument was, that the motion had a figure of I think I'm going off memory, $938 or something like that. But they came to court and somehow dropped down to $500 or 500 and some odd dollars, but I didn't see any new proofs. And so I didn't know what the basis for the reduction of $40 was. And that's a small amount, relatively speaking, but it's still important, I guess, to my client.
Sure. So looks like there was an order presented under the 7-day rule regarding this matter, and then subsequent to the expiration of the time, it looks like the court signed the order. Counsel, tell me where you are with this matter for defendant.
Yes. So as detailed in our response that we filed to this motion, we filed a reply brief to our motion for summary disposition, arguing that plaintiff's max claim was limited to $540.74 through December 30th, 2024. We presented for oral argument on January 15th, 2025, where we argued that plaintiff's max claims were limited to $540.74. During that hearing, plaintiff's counsel made no objection to that amount, and therefore the court granted our motion. And following the hearing, we reached out to plaintiff's counsel with an order that reflected the terms or the court's ruling. Having not received a response, we submitted the order to the court under the 7-day rule. Following submitting the order under the 7-day rule, we did receive a response from plaintiff's counsel where they agreed to the order that we sent them and that we sent under the 7-day rule. And now, weeks later, they're seeking relief from an order that they had no objection to on the record and that they agreed to in writing via email when we submitted it to them. For those reasons, plaintiff's motion should be denied. And we're also seeking sanctions because this motion was not grounded in fact. It was not a good faith argument. And for those reasons, my client should be entitled to costs and attorney fees for him to respond to this.
So, counsel, let me ask you. I'm looking for the underlying motion in this matter that gave rise to the limiting of the amount. And so, in regard to the defendant's motion to cap the amount, did the motion call for something more than the $500?
Yes, Your Honor, that was in our initial motion, but since filing that motion, plaintiff produced discovery responses that contained an updated billing ledger. And in that updated billing ledger, which was produced after our motion was filed, it showed a max balance of $540.74. So when we filed our reply brief, we attached that in support. And again, we argued that plaintiff's max claim were limited to that amount through December 30th. We actually attached that ledger to our response to plaintiff's motion before the court today, also showing that balance. And plaintiff had no objection during oral argument. This order was an accurate reflection of the court's opinion on January 15th. And there was no palpable error, there was no mistake, inadvertence, anything.
Well, Your Honor, the problem with them attaching a new amount in the reply brief is, I never saw the reply brief, but more importantly than that, I can't respond to it in any way, shape, or form. I can't contest it. I can't verify it. I can't do anything other than deal with the motion that is initially filed. And that's what we dealt with at the motion hearing. And so that's where I'm at. If they thought the amount should be lower, there should have been a different motion filed so I'd have an opportunity to properly respond to that.
Your Honor.
I mean, that's like that's.
Go ahead. I'm sorry, Mr. Ford.
Well, that's like a summary disposition by ambush. I mean, we give you one emotion and we give you one amount in the motion, and then we change the number in the reply brief, and I'm stuck with my hands up, basically. I've been robbed. And that's how, and so that's the problem with that. I never had a chance to respond to this new figure.
Your Honor,
right.
May I respond?
My concern is that on the date that the motion was heard, I mean, it wasn't a contest at that time. At that point, I recall this matter where the plaintiff, the defendant stated on the record the 500 plus amount, and I recall Mr. Fortner saying we'll stipulate to that amount as the capped amount. So I'm wondering how we get to because I do see in the initial motion $936.91, but I remember the hearing where at the hearing there was a agreement. It really wasn't an argument on the motion. The plaintiff stipulated to the amount that was set forth on the record. If it was a stipulation simply to the motion, then of course if an amount different from the amount in the motion comes up, then obviously you stipulated to the motion, not to the amount. But the amount was stated on the record. And there was a stipulation that that amount would establish the cap. Let me hear from you, Mr. Court Defendant Yusuf. So,
Yeah, Your Honor, when we filed our motion, we still didn't have discovery responses that were current. We didn't have plaintiff's current billing ledger. They produced that after we had filed a motion to compel discovery, and after our motion for summary disposition was filed, they produced this updated billing ledger. They have a copy of that ledger as they produced it. Our argument was limiting their claims to that billing ledger. And there was argument on the record. I presented oral argument, and in response to our argument, plaintiff had no objection. He did not object to the relief we sought. So as far as a stipulation, I would characterize it more as no objection to the relief argued for on the record. And what's also more telling is when we reached out to plaintiff's counsel with the order, after we filed it as a 7-day order, they reached out and said, yes, please proceed. That further confirms that the amount we argued that plaintiff's max claims were limited to was accurate. It was an accurate reflection of the court's ruling. Plaintiff had no objection on the record, and they agreed in writing. And now weeks later, they're seeking relief from it. And there's no basis.
Well, there is a basis, you know, and one of the bases is clearly unequivocal under MCR 2.612 is mistake, inadvertence. And so when you file a motion for summary disposition, you state one amount and then change it at the time of the hearing. I'm thinking about the motion. I mean, about the motion and the figure that's in the motion. I didn't have an objection to that. But I wouldn't. But I'll respect your ruling, and we'll try the case under $538. I don't mind. I mean, you know, they'll end up paying me a whole lot more than that, and $500 is a whole lot easier to prove than $900. So I respect your ruling.
yeah, I guess I'll treat the motion as a motion to reopen the proofs on the aforementioned amount. And I think that I haven't heard anything that would give me a basis to really reopen the proofs regarding this matter. And for that reason, that motion will be denied. I don't think that there is a basis, although there's obviously work that's gone into this. I don't think there's a basis for any award of costs or attorney fees, as I don't. It doesn't seem that the motion is rolls out of any bad faith efforts here. It seems that what Mr. Porter, what Dr. Chiropractor is looking at, is a petition to reopen the proofs on a notion that there may be a higher amount that could be established. That motion is denied. No cost or attorney fees are awarded. Thank you. Good day, John.
Your Honor, so can we ask you for a trial date now? We're done with the proofs.
Your Honor,
Let's get this
Your
matter
Honor,
resolved.
Your Honor, we're going to be filing a motion for partial summary disposition as to interest and attorney fees, and we can have that filed by next week.
All right. So what I will do is I will go ahead and I'll go ahead and establish a trial date in this matter. I'm looking at
It's a one-day trial, Your Honor. It won't take us long.
yeah.
June 3rd.
Yeah, June 3rd. June 3rd at 11 o'clock again. June 3rd, 11 o'clock. And anything that's filed in the interim, you can file it, and the court will set a date on it, or it'll be heard on the date of trial. June 3rd at June 3rd, 11 o'clock again.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. All right, this is case number 24-164-209. This is Robert Orthopedic Services versus Progressive Marathon Insurance. The matter is before the court. Set on for a review. Your appearance for Robert's Orthopedic. Did Mr. Portner leave?
Maybe he did, Your Honor, but he is on this one with me. Thomas Goffis, P86795 on behalf of defendant Progressive.
Thank you. Thank you, counsel. Looks like Mr. Portner's trying to come back in. All right, Mr. Fortner. Counsel,
I'm here, Your Honor.
okay, I'm on the Roberts Orthopedic matter versus Progressive Marathon. Counsel for Progressive has entered his appearance, your appearance on behalf of Roberts Orthopedic.
Thank you. Thank you, Your Honor. Michael Fortner, on behalf of plaintiff P46541.
All right, thank you, counsel. So I have this set for review today. Somebody tell me what's going
on. Your Honor, on March 13th of this year, we submitted our offer of judgment. Mr. Ford, I don't know if you were able to take a look at that yet. But if it was for $843.86, we filed that with the court. I don't believe we received a response just yet, but it hasn't been too long. It's been about 2 weeks since we submitted it. So I don't know what you're thinking, Mr. Fortner.
Well, I haven't seen it yet, but if you want to give us a trial date, Your Honor, I'll happily take it.
All right. So there are no other matters that need to be litigated. It's ready for trial, you believe, Mr. Porter?
Yes, Your Honor. You can give us the same June 3rd date.
Okay, I'll set it for June 3rd at noon.
Okay.
June 3rd, 12 noon.
All right, thank you, Your Honor.
Thank you. And Mr. Fortner, when you get a chance to see that offer of judgment, let me know if that'll suffice to get this one settled.
Re-email it to me. I'll take a look at it when I get to the office.
I got you. Thank you.
All right.
And now the court calls case number 24-158635. This is Body Mechanic Physical Therapy versus Auto Club Insurance Association. The matter is before the court, and I have this set on for review as well. Your appearance for the plaintiff in this matter.
Yes, Your Honor. Attorney Michael Fortner, P46541 for plaintiff.
All right, thank you, Mr. Porter. For the defendant Auto Club. For the defendant Auto Club. I counsel for Auto Club today. Mr. Do you have any information in this regard?
No, Your Honor, I haven't spoken to anyone. But if you want to set up for trial for June 3rd, a couple of these cases get settled, and one of them will try.
All right, sir. I'll go ahead and set this one on, and let's see. Maybe all of them get tried. I've tried.
I doubt if all of them get tried. They'll work them out.
I've done some things like that before. All right. So Mr. Rebecki is back. I said it wrong, sir. My apologies. And I believe that is to the suffix 2636, Rodney versus Mina. Sir.
Yes, Your Honor. Sorry. What time on June 3rd?
10:30.
10:30. Okay. And any motion for summary disposition notice for that time as well?
Yes.
Okay. And then will this be in person or remote?
It's up to the parties. If either party want to be in person, it's in person. If nobody objects, you can do it via Zoom.
Okay. Thank you, Your Honor. Sorry about that.
Want to come in person? If you want to come in person, we'll set that up. Mr. Fortner?
Well, I don't want to come in person unless I absolutely have to.
All right. Council, no objection to the matter being heard via Zoom?
Haven't done one on Zoom before, so no objection, I guess.
And I wouldn't have an objection to council going down in person if he wants to argue in person. That wouldn't bother me.
Yeah, he's not having a problem doing it via Zoom. I mean, if you want to come in person, I have no problem with that.
Yeah, let me
Yeah,
I'll
here's
talk to
what-
Mr. Fortner and
Well,
we can
I'm not showing up in person unless it's a trial date. So but or unless the court orders me to, but you can go if you don't, if you think you're better that way, I don't mind.
So here's what you do. I got it set up for now as Zoom. If either one of you decide that you want to be in person, simply give a notice to the other party in writing that I am appearing in person and CC that to the court. That means that both parties would have to be here in person.
Well, wait, yeah, I don't want to
Understood.
be there just because he's got it, because he's, I'm busy. I don't know what I got to do the day that motion's got to be argued.
Absolutely, but the rule is that if one person wants an in-person trial, we're talking trial now. If one person wants
Oh,
an
we're talking
in-person.
trial. Oh, I thought you were talking motion. No, I'll be there for the
That's
trial.
June 3rd. The June 3rd is the trial date.
Oh, yeah, I'll be there for the trial. I thought he was referring to the motion, his SD motion.
All right, well,
No.
it's in person then on June 3rd.
Okay.
All right. All right.
Thank you, Your Honor.
Yeah, I'll be there for the trial, Your Honor. Thank you. I'm sorry.
Thanks both of you.
All right. Do I have another one, Your Honor?
No, Mr. Fortner, that completes,
Well, Judge, what about 437 at the end? It's Michael Porter. Second one from the bottom.
that case is 7.
Okay, thank you.
All right. So, Mr. Fortner, you'll need to be here on the 3rd of June.
Okay, I will be there.
All right. Thank you, sir.
No, thank you, Your Honor.
Okay.
Ooh, that's gonna be a long day, Judge. I'm gonna have to take off that day.